Hello, everyone. I'm Julianne Story, partner in our Kansas City Labor and Employment Group. Welcome to our annual Kansas and Missouri Labor and Employment Legal Update. We're back this fall with our virtual seminar series, and we're glad to have attendees from across Kansas, Missouri, and a few other places joining us today. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them via the question box. We'll try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it'll be answered later via email. A PDF of the presentation and other resources are available in the Resources folder. This program has been approved for HR and legal continuing education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We do use your feedback to plan future programs that are applicable to your business needs. That's all for the housekeeping items, so let's get started with our program. We have 5 sections of content, and all 5 will be about 15 to 25 minutes in length. Please be sure to take a break as needed, as we won't have any formal program breaks within the program. First, we have our first section, Tim Hilton and Rachel Kim Walter from the Kansas City Employment Group. To set the table for their presentation on religious accommodations, we have our first poll question. And while you're answering the poll question, I will introduce Tim and Rachel. The poll question is, what is the most common religious request for accommodation that you've received? Answers: A, vaccine mask related, B, dress code related, C, schedule related, D, other, or none. As we head into fall and with Halloween around the corner, I asked the presenters to share their favorite childhood Halloween costume and favorite Halloween treat. So in addition to their professional background, I'm going to share those fun facts about our presenters. Tim Hilton is a labor and employment partner in our Kansas City office. He is a comprehensive advisor and litigator for companies with labor and employment issues. He helps clients navigate the ever-changing waters of federal compliance, particularly involving Title VII, the Americans with Disabilities Act, and the Family and Medical Leave Act. Rachel Kim Walter is a labor and employment attorney in our Kansas City office. Rachel represents employers facing a variety of labor and employment claims in state and federal courts and before administrative agencies like the EEOC and the Missouri Human Rights Commission. Tim's favorite Halloween costume was back in 1992 when he dressed as President Bill Clinton, including with a toy saxophone. Tim's favorite Halloween candy is Reese's Cups, and Rachel dressed as Mulan as a child for Halloween. She favors Twix candy bars. Let's see the results of our poll. It looks like a majority of the accommodations based on religion are schedule related as opposed to vaccine or mask related, and a few with dress code related. So about a little over 40% of the accommodation requests are schedule related. Rachel and Tim, does that seem surprising to you? I'm gonna hand it to you now.
Thank you very much, Julianne. Happy to be here. And yeah, I do find those results to be a little surprising. I would have thought that COVID, still mask-related, vaccine-related things would have been the majority, but we'll talk a little bit about a number of different possibilities. I want to thank everyone involved for not contacting my mother for a picture of me as Bill Clinton, and I'm sure she could have obliged. And I want to thank Rachel for whispering to me that she wasn't even born yet when I had that Halloween. So that was very helpful. So as Julianne said, we're going to talk about religious accommodations in the workplace today. I hope this is a topic that you'll find interesting and helpful. It's not necessarily the number one thing that we think of or that HR professionals deal with on a daily basis. But I looked at the data, and religious discrimination claims have increased steadily over the last 25 years as a percentage of the total EEOC charges made, including spiking to close to 20% of all total charges in fiscal year 2022. I assume that that's an anomaly due to COVID-related mask and vaccine accommodation issues, but still, this is a topic that we do come across, and I think due to the recent Groff case, which Rachel is going to talk about, and unfortunately, maybe the divisiveness of the current public discourse on issues of religion and politics, it may be something that we come across more and more. So Rachel is going to lead us off today talking about the recent Supreme Court case involving the Postal Service. Rachel?
Thank you, Tim. I'm excited to talk about we are excited to talk about religious accommodations. It is a topic that may not come up day to day, and it is something that we all are, as the audience is probably somewhat familiar with, the general law of requirements to accommodate an employee who needs a religious accommodation, and going through the interactive process of balancing the employer's needs with respect to whether or not it causes an undue hardship or cost. So with that being said, the question is, why are we talking about it today? Well, the law has not changed for 50 years with respect to religious accommodations and the undue hardship standard until this summer, when the Supreme Court issued Groff versus DeJoy. In summer of this year, in June, I believe, the Supreme Court made a unanimous decision clarifying the undue hardship standard and arguably changing it. So we're going to talk a little bit about that case to kick us off, and then Tim will talk later about the undue hardship. So this is a really good time to not only talk about the case, but to refresh ourselves on those basic requirements on what is religion, what is sincerely held belief, what are my obligations in the interactive process, and balancing an accommodation request with whether or not it causes undue hardship. So very briefly about this case, Gerald Groff was a plaintiff who worked for the U.S. Postal Service, USPS. He had worked there since 2012, and he is an evangelical Christian. He practiced, and his belief was to not work on Sundays, as Sundays are dedicated to rest and worship. And for many years, he was able to get away without working on Sundays. There was a time where mail was not delivered on Sunday, but with the rise of e-commerce and Amazon, that changed over the years. And so over the years, he was able to get away with this through exemptions, transferring to a post office that didn't deliver on Sundays, or finding others to cover for him and work for him on Sundays. But as we all know, with the rise of Amazon and Sunday deliveries, that became harder for the post office to accommodate and exempt him. So at a certain point, the post office was unable to find volunteers to cover his shifts on Sundays, so he requested an exemption to not be required to work on Sundays, which the post office denied because it caused an undue hardship, because they would have to bring in other employees or have other coworkers cover for him. They progressively disciplined him for not coming in, not working on Sundays, and eventually he did resign, and then he sued. So at the district court, the district court granted summary judgment for the employer, holding that it did cause an undue hardship on the post office, and the Third Circuit affirmed. And then interesting, Supreme Court unanimous decision, as I mentioned earlier, completely reversed and changed the standard, which is what we're here to talk about. All right, so the Supreme Court said that the undue hardship, which we're all familiar with, really just means, if you look at the definition, just some sort of burden to bear. So it's arguably, from the Supreme Court, an employer can avoid a liability if they prove some sort of burden the accommodation puts on them. And here with the post office, the focus was, it's going to disrupt the workplace, disrupt morale. We're going to have the impact on employees, which is the analysis we're all familiar with. How is the accommodation going to disrupt their coworkers? The Supreme Court decided it has to be something more than that, and you have to take in consideration the cost and the size of the employer. So the new standard now is that an employer denying a religious accommodation must show that the burden of granting the accommodation would result in a substantial increased cost in relation to the cost of the particular business. So it is a much more rigorous standard, and per usual, the court didn't give a lot of guidance on what does that mean, substantial increased cost in relation to the conduct of the particular basis. Well, it's case by case. It's going to depend on the size of the employer, the resources of the employer. This is something that especially larger employers like USPS should be very wary of, as they have more resources and employees. And we're going to talk more about this undue hardship standard, but it's something completely new since the last 50 years. So we thought it would be a good time to have a refresher on the basic requirements on religious accommodations and how this new standard is going to apply when employees request religious accommodations. So I'm going to turn it back to Tim.
Thank you very much, Rachel. Yeah, so religious accommodations religious discrimination is always a topic that I always remind clients that it's one of the few in Title VII where you have to have affirmative protections other than just the negative protections of you can't tell someone we don't hire based upon religion, we don't hire based upon a protected characteristic, in addition to disability. It is also one where the exact definitions and boundaries of what is a religion and what is a sincerely held belief aren't always perfectly clear. So we're going to talk a little bit about that right now. As you all know, Title VII of the Civil Rights Act and the Missouri Human Rights Act prohibit discrimination on the basis of a protected class, including religion. It applies to employers, employment agencies, and unions, and specifically defined religious organizations and religious schools are exempt from certain of the discrimination provisions. The ministerial exception under Title VII has been around for several years and was expanded in 2020 in the Hosanna Tabor case to say that employees, basically any employee that has significant religious duties is not eligible to make a claim under Title VII to avoid interference of the law with the inner workings of a religious organization. The Missouri Human Rights Act has a slightly different and a broader exemption in that certain religious organizations or certain entities that are owned or operated by a religious organization are exempted from the Missouri Human Rights Act, regardless of what the type of employee at issue is. So under Title VII, a person that has religious duties will be exempt under Title VII and under the Missouri Human Rights Act, but a person without religious duties, if they work for a religious organization, the entire organization may be exempt under the Missouri Human Rights Act. So then it gets to the question of what is religion. It is broadly defined in Title VII as all aspects of religious observance and practice, as well as belief. Unlike things you may have read about conscientious objectors related to the draft and things like that, it does not need to be associated with an organized church of any sort. That's something we often hear when I get calls about religious requests for accommodations, like, well, is that a real religion or anything like that? And really, if it is a sincerely held belief, it does not need to be something that is theistic or believes in a supernatural higher power or anything of that nature. Rather, the Title VII regulations cover, quote, moral or ethical beliefs as to right and wrong, held with the strength of traditional religious views. So what that boils down to is you should assume that a belief is sincerely held, and unless the person is telling you plainly that it is simply their personal non-religious belief, you should also assume that it will be covered by Title VII. Those are things that you can look into, but it is important to be cautious when questioning someone about their religious beliefs for obvious reasons, and it may cause them to feel that they're being discriminated against, even if you don't intend that. The sincerity of a religious belief is generally presumed and easily established. You can ask for supporting documentation when you have an objective reason specific to the individual to believe that the request is not based upon a sincerely held belief. So Rachel's going to talk a little bit kind of about the process of how that works.
Yeah, so as Tim said, that the default rule is that we assume that the employee has a sincerely held belief. But that being said, if an employer, if you have an objective reasoning for questioning that sincerity, that is permitted. So this comes up, and we have a couple of examples on the slide, in the context of COVID with a vaccination exemption. If the employee has received and reported receiving the yearly flu vaccine before with no objections, then that could be, an objective reason. Okay, why are you now asking for an exemption? And the second example is that in the context of an employee trying to receive an accommodation of a shift change, an employee has been bragging and boastful to his colleagues that he's going to lie about being religious to get an exemption. So those are just a couple of examples of objective reasons where you would be justified in questioning that sincerity. With that being said, there is no black letter requirement rule of how you prove your sincerely held religious belief. It can be something as simple as an oral statement from the individual explaining their religious belief. It can be an affidavit, a written statement talking about their religious belief. It can be a statement from a religious leader, pastor, colleague, friend. It can really come in any shape or form. So very briefly on what is religious accommodation. Religious accommodation arises when the employee's beliefs and their practice conflicts with their particular task they're required to do or their position. So that's when the employer's on notice that they potentially need to offer religious accommodation. A religious accommodation is an adjustment to the work environment that will allow the employee to comply with their religious beliefs. So pretty simple. And we have talked about some examples, even with the poll today, work schedules, dressing, grooming, etc. In the interest of time, we're gonna go to the next slide. All right. So as we talked about earlier, reasonable requests for accommodations must be granted absent an undue hardship to the employer. And their reasonable accommodation, no, you're fine. Reasonable accommodation is one that eliminates that conflict, as I spoke about earlier, between the requirements, so the position and the particular task the employee is required to do, and the employee's religious practice. With that being said, a reasonable accommodation is reasonable, and it doesn't mean that the employee must be satisfied with the accommodation or it must be the accommodation they initially asked for. You go through that interactive process. Guys, we're back to Tim.
Thank you. Yes. So on the undue hardship standard, I am going to skip ahead a little bit for time, but we can, Yes, we can expect, as Rachel said, the Groff opinion doesn't necessarily give a lot of guidance. This has been kicked down to the lower courts, and we can expect that over the coming years, the circuit courts and other courts are likely going to be developing their tests and standards, and we'll have to see in the coming years how those develop. I am going to skip ahead to a few examples. I want to skip ahead to these will be in your materials. But for example, an employee requests a change of tasks. An employee doesn't believe in, due to her beliefs as a Jehovah's Witness, in celebrating birthdays, and she's a server at a restaurant. In the situation where the manager refused any accommodation, the individual would likely prevail because we could easily substitute in another server to cover that. With the similar to the Groff case, a lineman requests accommodation for his Sabbath observance, but because the nature of his position requires being available to handle emergencies, we can't permit him to remain in that position. The employer can accommodate the lineman by offering a transfer to another assignment at the same pay, and if that's not available, they could transfer him to a different job. And one that I think is illustrative here deals with grooming standards. An employee in a medical setting doesn't trim his beard due to his Sikh beliefs, and he's offered the idea of wearing 2 masks, which he doesn't want to do for non-religious reasons. In that context, we've offered him an accommodation that he's turning down for non-religious reasons, so the employer would likely prevail. So we're going to finish up real quick, Rachel, do you want to talk a little bit?
Really quick. Sorry, I talked too much. So now in practice, the employees requested a religious accommodation. Now what? Well, it's everything that we've talked about today. We engage in that interactive process dialogue with the employee to determine whether or not a reasonable accommodation is available. So getting clarity on what exactly accommodation is requested and comparing that with the position and the task that needs to be done, and gather as much information about the possible accommodations. And then for our final slide, of course, if it wasn't documented, it wasn't happened. Document all requests, conversations, and considerations, so there's a clear record of the interpractive practice if unfortunately it leads to some sort of dispute or even litigation. With that being said, with documenting, clearly communicate the decision to the employee. Just document the decision, typically in a letter. And if the employer can accommodate, clearly outline what the accommodation entails and the expectations of employees. And of course, when in doubt and with these issues with the new Supreme Court decision, please don't hesitate to contact us and reach out to us to go through and talk through these issues. Thank you.
Thanks very much, everybody.
Thank you so much, Tim and Rachel. That's a topic that should be on the radar for all employers these days. Next up, we have our second group, Ben McMillan and Adam Dare, who will discuss recent developments at the NLRB. The poll question tied to their presentation is, does your company train supervisors and managers on positive employee relations? A, yes, but that training has taken into account recent NLRB decisions. B, yes, but not in light of recent NLRB decisions. C, I'm not sure, I'd have to ask. D, no. E, what is positive employee relations training? While you complete your answers to the poll, I'll introduce Ben and Adam. Ben is a labor and employment partner in our Kansas City office. He defends and guides employers on a wide array of workplace matters. An experienced litigator, Ben successfully represents clients in state and federal courtrooms and in union arbitration hearings involving complex matters. For Halloween, Ben recalled dressing as a Raider hater. And although he is not in costume today, he tells me he is still a Raider hater. His favorite candy is Milk Duds. Adam is a senior L&E counsel in our St. Louis office. With a strong background in management defense and traditional labor law, Adam advises clients on union avoidance, union relations, contract administration, unfair labor practice allegations, collective bargaining negotiations, and grievance investigations. Adam recalled dressing as a lion when his family went as a group, as the Wizard of Oz characters for Halloween. And his favorite candy is Snickers. And Adam and Ben, it looks like a majority of the attendees are conducting training on positive employee relations, but most in that group are not, have not adapted the training to the recent NLRB decisions. So I will leave it to you to explain what should be happening.
Okay, well, thank you very much, Julianne. As Julianne mentioned, my name is Ben McMillan. I'm a partner here in Kansas City. I work exclusively in the area of labor and employment. I would say 25% of that is in the traditional labor space, the traditional labor area. That's what we're going to be talking about with you today, the National Labor Relations Act. Now, many of you might be thinking, okay, this doesn't really apply to me. My workforce isn't unionized. Instead of listening, I'm going to hop online and find out the latest on the Travis Kelce, Taylor Swift saga. Now, as interesting as that is, and it is interesting, I would implore you to stick around and listen, because contrary to popular belief, and it is a common misconception, probably the most common misconception I've encountered in my career, the National Labor Relations Act protects the rights of employees to bargain, to communicate, to complain about workplace conditions collectively, regardless of whether that workforce is unionized or not. So the decisions we're going to be talking about with you today, the changing trends, the definition of protected activity, all the nuts and bolts that we're going to get into. This applies to you, regardless of whether you currently have a union or not. But we're delighted to have the opportunity to talk with you today, and we're going to get in now to the agenda. So I'm going to start by just talking with you all about changing trends and the directions we see unions going in the United States. It might surprise you. There are many misconceptions about where we are now, kind of where we've been, and the trends, and some of them are kind of counterintuitive. So we're going to get into that momentarily. Adam is going to talk at length about two significant opinions that just came down from the National Labor Relations Board. Those opinions are significant in that they affect both non-union and union workforces. There's going to be discussion about the content of employee handbooks, about communication in the workforce. Can you even regulate profanity in the workplace? These are the kind of things that we're seeing the NLRB wade into when we talk about protected speech. So Adam will talk at length about that, and he's going to kick it back over to me to talk about how we recommend dealing with these developing trends. Okay, changing tides and general trends. By a show of your virtual hands, how many of you believe that union membership is down currently? There's no way for me to know the answer, but it is always an interesting question when talking with folks about their beliefs about the modern American workforce. Well, if you answered yes, you believe union membership and activity is down, you would be wrong. With data from January through June of 2023, there were almost 830 elections held. Unions have won 80% of those elections. So the trend, as we see, is going up for union membership. Approval rating is also strong at about 67%. Now that's down just a little bit from last year, but it's up a lot from about 10 or 15 years ago here in the United States. So the public generally has a better view of unions and their purpose and what they do for the American worker than they did about a decade ago. And again, union membership generally is up by about 25%. And that's significant when we see that the total number of employees who are involved in these elections and added to these bargaining units. So again, regulations about speech and conduct, those all apply to you equally, regardless of whether you have a union workforce. But if you don't have a union workforce currently, there may be one coming. So that begs the question, why is all of this so important? And I'm going to turn it over to Adam to talk with you about, at first, the breadth of concerted, protected activity under the NLRA. Obviously, everything an employee does isn't protected by the NLRA or Title VII or anything of that nature. But we're finding more and more that the scope of what that activity is and what's protected is being expanded by the board. So with that, Adam, I'm going to turn it over to you.
Thanks, Ben. I hope I don't talk at length about this for time constraints and interest constraints, but I could spend all day or all week talking about these topics. It consumes the entirety of my professional life, and I'm happy to share some of that perspective with you today. Why is this so important? And the breadth of protected considered activity is really just the first piece about why this is so important. The protected concerted activity, when we're talking about PCA under Section 7 of the National Labor Relations Act, we're talking about pretty much any conduct that involves more than one employee with an object towards improving their wages, benefits, or other terms and conditions of employment. So as Ben alluded to and mentioned, those rights apply to virtually all private employers in the United States, and most public employers are subject to similar requirements under state public sector labor laws. But under the NLRA, protected concerted activity typically requires that the conduct be concerted, meaning involving two or more employees, and protected, meaning relating to a subject matter that pertains to their terms and conditions of employment. But the law carves out from the definition of employees independent contractors who are separate from employees under the law, and supervisors, capital S supervisors, which are separately defined under the NLRA to mean certain individuals who have one of a specific list of authorities in the statute. So we're talking about employees' rights under the NLRA here, not independent contractors or supervisors or other small categories of workers not encompassed. And of course, it does apply regardless of whether or not a union represents your employees currently in the workplace. These are some of the work rules, whether it's in a handbook or a standalone policy or just the way you do things. These are some of the work rules that often implicate protected concerted activity. And some of the ones that I have highlighted there in red have come under the most heavy scrutiny by the NLRB really in the last 2 or 3 years, and even more so just in the last couple of months with the Stericycle decision that I'll address next. That decision just changed the framework by which these rules are evaluated. Confidentiality rules are often found to be overbroad under the NLRA because they either explicitly or can be interpreted to restrict employees' rights to talk about issues pertaining to their workplace, whether it's wages, benefits, disputes, alleged discrimination, safety, anything that is an issue in the workplace and they're seeking to better can be part of a conversation in the workplace or outside the workplace. And that includes confidentiality rules pertaining to investigations, because employees have the right to discuss with other employees or other individuals the concerns they have, what they've raised, what that process looks like for them, and countless other aspects of an investigation. So the employer can suggest and assure to the employee that the employer will not blab their statements to others, but we cannot require employees to refrain from sharing information, discussed in connection with the investigation. And when I say that, I'm talking about these days. Labor law is one of those laws that shifts dramatically depending on who's in the White House. And that's not me getting political. It's just true that, especially over the last several administrations, we've seen how labor law shifted decidedly left under President Obama, and it swung decidedly right under President Trump, and it has swung decidedly back left under President Biden. So when we're looking at work rules, we have to keep in mind how this current NLRB will view these rules, even in the absence of actual decisions or existing law currently making it unlawful. And that's a little bit of a risk tolerance for our clients to consider whether they want to dare the NLRB to make their company name the next precedent-setting case. Civility, workplace civility, and required professionalism kinds of rules also come under attack because employees under the Act have the right to be upset, to be angry, and for conversations to get heated and even offensive. So sometimes the NLRB is looking at those kinds of required civility rules as overbroad because it's restricting that discourse from taking place. Solicitation distribution rules generally target verbalized requests to support or join an organization or a cause. That's the solicitation. And then the distribution refers to handing out paper materials or laying those around a break room. And currently, solicitation can be controlled, meaning we can restrict solicitation into non-work causes so long as we have consistently enforced that rule to apply to all non-work causes, and so long as we restrict that restriction, we only prohibit solicitation during actual working time, the time they're supposed to be productive, not to include break times, lunch times, other non-working times between shifts and what have you. And then with the respect to distribution, again, those rules must be enforced uniformly with respect to Girl Scouts, United Way, you name it. Once you allow those kinds of materials in the workplace, you can't discriminate against union material and restrict the distribution of union material. But similarly, distribution can be restricted to non-working areas so that we can still maintain a clutter-free workplace and a safe work environment for our production employees. Dress codes have become squarely under attack by a case involving Tesla last year. Simply put, our dress codes cannot in any way restrict an employee's right to wear union insignia, whether it's a button or a hat, or depending on the nature of their job, a pullover, a sweatshirt, a jacket, a t-shirt. It's really hampered employers' ability to maintain a singular appearance for its employees. And that's a challenge a lot of companies are grappling with on the heels of that Tesla decision. And then social media and other kinds of computer use systems policies also come under attack because we can't restrict their ability to air their grievances, so to speak, or engage in protected concerted activity online. The fact that they're on Facebook or Instagram or Twitter or X, whatever it's called next, doesn't remove the fact that it's concerted and protected if it otherwise is. So that's just been deemed essentially the modern day water cooler. So even if it's not happening in our workplace, the conduct may still be protected under the Act. So that's just a handful of them. Here's a quick little quiz, if you will. Here's an example of a case situation that came up. An individual employee essentially raising all kinds of concerns about COVID and protocols being exposed. And the employee ended up telling the supervisor that he thought the company should close after somebody was sent home because of their wife contracting COVID. And the question here is this protected concerted activity? And hopefully everybody understands and agrees that yes, especially these days, this kind of conduct is protected concerted activity because it pertains to employees' working conditions, their health and safety at work. Let's go to the next one, maybe a little bit weirder, if you will. An employee alone seeking support for a former employee to be rehired. And the question is the conduct in connection with a former employee count as protected concerted activity in your workplace? And the answer here, again, is yes, even though the administrative law judge in the first round thought no. But the rub here is advocating for even a non-employee, if you will, still did pertain to their workplace. And the decision and the criteria used for hiring somebody back, or hiring anybody for that matter, does have a nexus to the workplace that they're currently in. The same was seen true, for example, in the Fight for 15 protests or Black Lives Matters protests. If there's a connection to diversity in the workplace or wages in the workplace that employees are rallying behind, even though it's an outside cause, it could absolutely still be protected concerted activity under the Act. In this case, just because they're a former coworker, that didn't remove the conversation and the conduct from the protection. The employee did seek to be rehired. And again, the key takeaway there is it doesn't have to be between two existing employees. And frankly, it doesn't even have to be with two employees. A single employee's effort to engage, an effort to initiate group activity can itself be protected concerted activity, even though it's really only being undertaken by one individual. So that's the breadth in 10 minutes of protected concerted activity. On the heels of that foundation, we have these two decisions that came out really recently, Stericycle and CMEX, back-to-back, two of the most impactful decisions I've seen in my 12 years or so. Stericycle came first in sequence here, and that addressed the framework by which the NLRB evaluates the lawfulness of work rules. Again, in whatever context they may appear, whether that's severance agreement, which was handled more specifically in another case, but the common context is handbook rules. And this case in particular addressed these particular rules: personal conduct, workplace language, conflicts, and confidentiality with respect to investigations. And the upshot here is the previously existing Boeing framework, which became famous for its three categories of presumptively lawful, maybe lawful, and presumptively unlawful work rules. All of that was upended in largely a return to precedent, but with a slight modification. Here, every rule will be separately evaluated, but first step is to the board asks whether an economically dependent employee, a reasonable economically dependent employee could interpret the work rule as encroaching on their Section 7 rights, anything that could constitute protected considered activity. If so, the work rule is going to be presumptively unlawful unless both of the next steps are satisfied. The second step there then is whether there's an overriding legitimate business interest furthered by this work rule. Oftentimes we'll be able to establish that there is a legitimate business interest, but the fact that it's an overriding interest is going to be very challenging to prove in a lot of cases. And even if we can prove that element of our defense, if you will, the last step is going to prove very challenging, which is demonstrating that the work rule is the most narrowly tailored that we could craft it. That means you could not prepare, draft, revise it any further to better protect Section 7 activity. This is the most narrowly tailored rule we can have to further our interests without encroaching on Section 7 rights. So taken together, demonstrating that overriding legitimate business interest plus that the rule is the most narrowly tailored possible we could have it is going to make proving the lawfulness of our handbook rules very challenging moving forward. Key takeaways are to make sure that your work rules, whether they're in handbooks or otherwise, are reviewed. If they haven't been in the last 2 months, that's about the window looking back before the review has been a little bit stale in light of recent decisions. So if it's been a couple of months, certainly if it's been a year or two, it's a good time to make sure you're reviewing those and revising them so that we can pass the board's scrutiny. And then, of course, when you're developing or revising work rules, be sure that the reasons for them are carefully documented to establish that legitimate business purpose. And maybe even track changes, show the development and the progress and the revisions of that work rule to show that we did go through that process of making sure it was the most narrowly tailored version that we could come up with. And then there's a small list of reminders, some key rules that have really become the hot button rules that the NLRB is scrutinizing most often. So on the heels of that, now that we know all of our work rules are unlawful and it's really hard to convince the board otherwise, now we get this decision on August 25th that says, by the way, any slip-ups of the law could subject the company to having to bargain with the union without ever having an election take place. So backing up a little bit, usually before August 25th, the process would be a union comes to a manager's door and demands voluntary recognition based on majority support. The manager says no thanks, and the union files a petition for an election, which happens 4 to 6 weeks later. But now, if we get confronted with that demand for recognition and the claim for majority support, and if we just say no thanks and do nothing further, the union is in after 2 weeks. Unquestionably in, except through appeal through ULPs alleging refusal to bargain with the union, where you then have to challenge that they actually didn't have a majority support. And it's a little bit of a cumbersome process that I don't recommend engaging in unless you've thoughtfully considered your options. Instead, what we need to do when we're confronted with that claim of majority support and demand for recognition is we have 2 weeks to go to the NLRB ourselves and file what's called an RM petition. The union files an RC petition, employers file an RM petition. So if we don't file that RM petition in 2 weeks, there's a good chance that the union is going to be automatically in. What I'm seeing happen already is unions are coming with those demands for recognition and then filing their own RC petition. And the CMEX decision contemplates that might happen, but it doesn't say, as far as I can tell, what happens if 2 weeks pass and then the union withdraws that petition. Well, now have we lost our 2-week window to file that RM petition? Technically the time passed and technically we didn't file it. there's argument to support that we would still have an opportunity to get that election, but the language of the decision doesn't make that crystal clear. And this was not a doctrine that was promulgated by rulemaking, which goes through the benefits of public comment to hash out those details. So instead, this is a decision that just upended how things are done. And my recommendation is to make sure that we docket 2 weeks out and make sure we file an RM petition before then, even if an RC petition's been filed by the union. Even still, if a petition is filed, whether it's RC or RM, and the board finds an unfair labor practice was committed, that alone can result now in a order from the NLRB that we must bargain. We have to sit down and bargain with the union. It doesn't establish that same certification of representation, but it does affirmatively require us to now bargain with the union and give them a fair chance to reach agreement. So the upshot of all this, with the expansion of what constitutes protected concerted activity, how the board has really revised how it evaluates the lawfulness of those rules, and the impact of those rules, and just any violation of an employee's Section 7 rights now opens the door to direct bargaining orders and potential relationships with union without ever having the benefit of a free, fair, secret ballot election. So if I could have the benefit of hours and weeks to talk about this more, I would fill up every minute. But for now, I'm going to have to punt it back to Ben to give us some options, best practices, recommendations on how we can proceed with an issue-free, positive employee workforce.
Thank you, Adam. Very informative, full of great detail. Adam ended with the discussion of how it's just a lot easier for a group of employees to come together and form a union and have that union formally recognized. I want to talk with you now, just for the last couple minutes that we have, on how we can avoid that. As you can see on the slide, everything I'm about to discuss briefly with you involves how an employee feels about the way they're treated, how they feel working at your location, and whether or not they feel like they can do anything about it when problems arise. So number one, training leaders on positive employee relations. We spend a lot of time talking about training over Title VII issues, harassment, discrimination. Obviously, that's very important and vital that employees be trained and managers be trained in that area. It's also very important that they be trained on how to best deal with and relate to employees. Under that same vein, making sure managers understand how to receive, process, and investigate complaints, including how to bring about resolution of those complaints and making sure employees feel heard through that process. Obtaining employee feedback and really being open to what the boots on the ground, if you will, have to say about how that workplace works, how it functions, whether or not it's a good place to work, whether or not there are things that can be done better, and within reason, if any of those suggestions can be implicated. Providing competitive, livable wages. I'm always pleasantly surprised by a lot of my employees when I'm at the bargaining table, how often, on one hand, they're trying to negotiate, push wages down in negotiations, but also recognizing, hey, we want to pay these folks enough that we can recruit, retain, and ultimately promote top talent and pay these folks in a way that shows that we appreciate them. Providing a safe and healthy work environment, ensuring fair and consistent treatment. Again, we could talk at length about all of these things, but the overarching dominant theme here is the best way to avoid a union is to have your workplace be a place where folks don't feel like they need an advocate, where they feel like, number one, it's already a great place to work, and number two, to the extent I have any problems or complaints, I know that I've got a mechanism to bring those complaints and concerns to management, and I'm confident they will be heard and dealt with effectively. So thank you all so much for your time today. It is always a pleasure getting the opportunity to get in front of you and talk about what's going on in our world and how it affects what's going on in your world, and we really are grateful. With that, I'm going to turn it back over to Julianne.
Thank you, Ben and Adam. Lots of potential pitfalls for employers. Next, we have Kate Copen and Eleanor Kittelstad, who are going to discuss employer obligations as to pregnancy in the workplace. Relevant to their presentation, our poll question is, does your facility have a space for employees to pump that meets the requirements of the Pump Act? A, yes, we have dedicated lactation room for employees. B, yes, we have a private room that can be used for pumping and meets the requirements of the law. C, not yet, but we're working on creating a space. D, no, we do not have any employees with pumping needs. As you complete the poll, I will introduce Kate and Eleanor. Kate is a partner in our St. Louis office. She has significant trial experience. She's handled and won multiple jury trials, including as the first chair attorney in the case. She has obtained favorable resolutions in proceedings filed in numerous state and federal courts and in front of various administrative agencies. Eleanor is an associate in our Kansas City office. Much of Eleanor's practice is devoted to employment litigation defense, and she is passionate about protecting clients' interests in court. Kate recalled dressing as Jasmine, with her brother also dressed as Aladdin for Halloween. She also likes Reese's peanut butter cups as her favorite candy. Eleanor dressed as a Hershey's Kiss one year when she was a child, and her favorite Halloween treat is caramel apple pops. Let's see the results of the poll. It appears, Eleanor and Kate, that most employers represented in our audience do have facilities within their workplace that for employees to express milk, although not a dedicated lactation room for most of those employers. I'm going to send it over to you now.
Thanks, Julianne. I feel like that poll question was a little unfair because it asked people if they're complying with the requirements before we explained what the requirements are. But don't worry, we're going to do that in the next 15 minutes. Here we go. So Eleanor and I are going to be talking about two recent laws related to pregnant workers that just went into effect. Both the PWFA and the Pump Act were signed into law by President Biden in December of 2022. The Pump Act went into effect immediately upon signature, but earlier this year in May, the Department of Labor put out some enforcement guidance. So we're going to be talking about that and what that guidance says. The PWFA went into effect also this summer in June, and just a little over a month ago in August, the EEOC put out proposed regulations, which we're going to be focusing on today. Those proposed regulations are currently open for public comment, but only for 5 more days. So if you would like to submit a comment, you have until this coming Tuesday to do so. So I'm going to pass this over to Eleanor to talk about the Pregnant Workers Fairness Act.
All right, thank you, Kate. Okay, so in a nutshell, the Pregnant Worker Fairness Act, or PWFA, is a federal law that covers all employers with 15 or more employees and requires employers to provide reasonable accommodation for pregnancy, childbirth, and pregnancy-related conditions. So I'm going to just do sort of a 30-second history on sort of pregnancy in the law so that we can understand how the PWFA is different than what was in effect before this law was passed. So we've had the Pregnancy Discrimination Act in place for decades now. The Pregnancy Discrimination Act amended Title VII so that pregnancy discrimination in the workplace was prohibited by Title VII. But of course, the PDA did not necessarily require employers to provide an accommodation for pregnancy or pregnancy-related conditions. We also have the ADA, which of course requires employers to provide reasonable accommodations for disabilities that fall under the ADA. Again, that did not necessarily require accommodation of pregnancy itself, although it did cover some pregnancy-related conditions in certain circumstances. And then finally, another law that's related to the PWFA is FMLA. So as we know, employers are required to provide 12 weeks of unpaid leave for employees at the birth of a child. And so, that's kind of some context that we can use to think about the PWFA. The PWFA exceeds all of that. And what's up on the screen right now is kind of the primary things that the law does. So first, covered entities must provide reasonable accommodations to a qualified employee or applicant with a known limitation related to, affected by, or arising out of pregnancy, childbirth, and related medical conditions. This is subject to an undue hardship analysis, which Kate will talk about here in just a moment. A couple other things that the law does. It says that employers cannot require an employee to accept an accommodation unless that would render the employee unqualified. Employers cannot require an employee to take leave if there's another accommodation that can be provided in the workplace. And lastly, employers cannot take adverse action against an employee for exercising their rights under the PWFA or requesting an accommodation. So that's kind of the highlights of the act, and Kate's going to get into the details.
All right, so what are pregnancy-related conditions? So obviously there is the state of being pregnant, which, fun fact, I happen to be right now. Baby is due in December. But the EEOC has explained in the guidance that it put out, it includes other related conditions, and listed on the screen here is a non-inclusive list of what some of those conditions might be. The last bullet point, you'll see other conditions associated with pregnancy. For example, that might be high blood pressure. And even if an employee, for example, has high blood pressure before they became pregnant, if their pregnancy exacerbated that condition and made their high blood pressure even higher, then that could still be a pregnancy-related condition that needs to be accommodated under the PWFA. So what are reasonable accommodations? The analysis is pretty similar to to the analysis under the ADA, which most of you are probably familiar with. These are also examples that the EEOC put out in its proposed regulations. The list on the left, the EEOC says, are virtually always reasonable. Not always, but virtually always. So, in most work environments, these would be examples of accommodations that should be relatively simple to provide. On the right are other examples that the EEOC has provided that perhaps are a little bit more involved, but still could be reasonable depending on the circumstances. And you'll notice the last one. This is a significant difference from the ADA, because under the PWFA, a reasonable accommodation could include excusal from essential job functions. As most of you are probably aware, under the ADA, an accommodation is only reasonable if it helps an employee to perform their essential job functions. But under the PWFA, an employee might be excused from performing those essential job functions. So that leads us to the question, well, when might an employee be excused from performing their essential job functions? And if these three elements are met, then that could be a situation where an employer may, not necessarily, but may need to excuse an employee from performing their essential job functions as a reasonable accommodation, assuming it doesn't pose an undue hardship. So the inability to perform those essential job functions must be temporary, which is defined as up to 40 weeks. They have to be able to resume their essential job functions in the near future. And of course, the employer needs to be able to reasonably accommodate that absence. Regarding the temporary period, so that doesn't necessarily mean that all accommodations must be provided for up to 40 weeks. It just means that if an employee is unable to perform the essential job functions for a period of no more than 40 weeks, then they could still be considered qualified, and the employer should go through the analysis to determine whether the accommodation they're requesting would be reasonable. And so what constitutes an undue hardship? Well, this analysis is also very similar to the analysis under the ADA. An undue hardship is an action requiring significant difficulty or expense. So just how you would analyze this under the ADA, you would take into account the nature and the cost of the accommodation, the size and resources of the facility, and the effect that the accommodation would have on other employees and the facility as a whole. If you're suspending the essential job functions or considering that, the EEOC has put out these additional factors that an employer should consider in determining whether that would create an undue hardship. Again, going to the length of time you would be doing so, whether there's other work for the employee to accomplish in the meantime, and whether others would be able to complete those essential job functions. So Eleanor is going to finish up talking about this act, the PWFA, and then we will get into the Pump Act.
All righty. Okay, so we're going to wrap up with just some best practices. A lot of this is stuff that you're probably already familiar with. So requests for accommodation do not need to be in writing, but it's important for you to put things in writing. Documentation is key. So if you're receiving a request for an accommodation or hear about a limitation that's needed and there is some kind of discussion about that, document it, have an interactive dialogue. A couple things to note with respect to asking for documentation of the medical condition that are unique to the PWFA. So if an employee asks for an accommodation related to pregnancy itself, such as extra water breaks, extra bathroom breaks, some of those things that Kate discussed that will sort of be considered per se reasonable. You do not necessarily need to ask for accommodation for that, documentation for that. But if the condition is not obvious, you're welcome to ask for documentation. The other thing to note is be cautious about making sure there's no delay with these sorts of requests. This is something that the EEOC particularly noted, just because this act involves temporary accommodation. So it's a little bit, the analysis might be a little bit different than what we have under the ADA with respect to unnecessary delay. So if you receive a request, just take prompt action for that. The last thing that I'll say about the PWFA before we move on to the Pump Act is that a lot of this information is based on the proposed rule that Kate mentioned. The EEOC is supposed to finalize a rule by the end of the year, so late December of 2023. So we will, of course, be monitoring that and keep you apprised of any updates that happen once we get the final rule. And with that, we'll go on to the Pump Act, providing urgent maternal protections for nursing mothers. So many of you are already familiar with the requirements of the Pump Act from a previous law. This is substantially the same as the previous law, but it has expanded coverage to many employees who were not previously subject to the Pump Act. So it's estimated that coverage has been expanded to about 9 million more employees than were previously covered. Now salaried employees are also covered. So we'll get right into the requirements. There is a reasonable break time requirement and a space requirement. So starting with reasonable breaks, what the law and the DOL guidance say is that employees are entitled to breaks each time they need to pump. So it's flexible, and some of the examples that the Department of Labor have given, is a wide range of what might be reasonable. So it could be 4 25-minute breaks during the day. It could be 2 30-minute breaks during the day. The key thing for you to know is that employees are not required to adhere to a fixed schedule. So it's about what their needs are. Frequency and duration can change over time. Reasonable time is also dependent on the facility. So consider how far does an employee have to go to get to the space where they pump? Do they need to go to a locker first? That sort of thing can factor into how long the break time might be. And then this is consistent with what the law was before. The break time is for 1 year after the employee has the birth of a child. We are going to now talk about space. So the key thing is that the space cannot be a bathroom, and it needs to be private, which means free from view and intrusion. Does not have to be a locked room. So even if you don't have a locking mechanism, if you have some sort of signage to note privacy, that's fine. The room must be available when needed. So many of you answered the poll question that you don't have necessarily a designated pumping space. Rest assured that is perfectly fine. It does not need to be a dedicated space, but here are the things that you do need to have in that room: a place to sit, a flat surface other than the floor, so some kind of table, an electrical outlet, and then other considerations. These are not things that you're required to provide, but may help improve efficiency: a refrigerator, a sink, somewhere to store your pump. And with that, I will send it back to Kate for some final notes about enforcement.
Yeah, so to wrap up talking about both of these pregnancy-related laws, so how are they enforced? The Pregnant Worker Fairness Act, the first law we were talking about, the EEOC enforces that. And just like under Title VII or the ADA, ADEA, there's an exhaustion of administrative remedies requirement. So employees have to file a charge with the EEOC first, alleging that they've been discriminated against under the PWFA, and then receive a right to sue. And at that point, then they could bring a private cause of action in court. Under the Pump Act, that is part of the Fair Labor Standards Act, so it is enforced by the Department of Labor. There is no administrative exhaustion requirement. But there is one exception to keep in mind. So if an employee wants to bring a private lawsuit based on their allegation that the space was not adequate, they have to first notify their employer and give their employer at least 10 days to correct. Now, again, this only applies to lawsuits, so an employee does not have that waiting period if they want to file a complaint directly with the DOL, and it only applies to the space, not the break time. So if an employee alleges, on the other hand, that they weren't provided adequate break time to pump, they do not have that 10-day notice period, and they can move straight to filing a lawsuit. So that wraps up our section, and we will pass it back to Julianne in Kansas City.
Thank you, Kate and Eleanor. You've discussed some important changes in the law that employers need to navigate. Next up is our presentation by our immigration folks, Kelly Mylink and Christine Fabian. And as an introductory poll for their presentation, is your organization an E-Verify employer? If yes, do you plan to engage in remote Form I-9 verification of employees? A, no, organization is not an E-Verify employer and does not qualify for remote verification. B, yes, organization is an E-Verify employer but does not intend to engage in remote verification of employees. C, yes, organization is an E-Verify employer and does intend to engage in remote verification of employees. D, not sure. So while you all are completing the poll, I'll introduce Kelly and Christine. And Christine is a labor and employment partner in our Kansas City office. Christine understands that in order for organizations to operate at their best, they need the best and brightest talent, which can mean hiring outside the U.S. or recruiting international workers and students. Christine works with organizations that hire many foreign nationals. Christine recalled dressing as Cleopatra for Halloween when she was a child, and her favorite Halloween candy, Reese's Peanut Butter Cups. Kelly is a partner in our labor and employment group in Kansas City also. She focuses her practice on business immigration, representing a wide range of employers in obtaining and maintaining employment authorization for foreign national employees on both a temporary and permanent basis. As to Halloween, Kelly fears insects that fly and sting, I-9 non-compliance, and costumes. So she preferred handing out the candy and would partake of the Reese's Peanut Butter Cups. Let's see what the poll results show. Looks like most of the respondents, 41.8%, of the organizations on the line are E-Verify employers and do intend to engage in remote verification of employees. Perhaps not surprising, given the post-COVID world that we're living in. Kelly and Christine, I'll turn it over to you.
Thanks, Julianne. I do fear I-9 non-compliance, and that's why we're talking about it today for the next 10 minutes. I'm Kelly Mylink. I'm here with Christine Fabin. We are co-leads of the immigration practice here at Husch Blackwell. And for the next 10 minutes, we're going to take you out of the traditional employment law realm, and we're going to talk a little bit about I-9 compliance, why the Department of Justice is investigating SpaceX, and then about that remote I-9 verification process and the new I-9 form. Christine will take us through that in the second half of this very short presentation. So let's get started. Okay, SpaceX. SpaceX is always in the news, but we're going to talk about why the Department of Justice is suing SpaceX, and particularly for immigration-related violations. The Department of Justice, you may not know, has this very small division of it called the Immigrant and Employee Rights Section. And they are charged with essentially upholding this statute, which is from the Immigration and Nationality Act, which also has its own employment-related or anti-discrimination provision in it that says it is an unfair immigration-related employment practice to employ or to discriminate against an individual and a protected individual on the basis of their citizenship status. A protected individual is a U.S. citizen, U.S. permanent resident or temporary resident, somebody who's a conditional resident who's not yet has their full 10-year permanent resident card. A refugee, somebody who has been approved for refugee status, not somebody who just calls themselves a refugee. Or asylee, which is somebody who has been approved for approved application for asylum, not just somebody who has applied for asylum. So here's what happened. So the Department of Justice has been investigating SpaceX for several years. This started with the last administration, is continuing through this administration, and they're saying, hey, we got a call from an asylee who said you didn't allow them to apply or hire them, or you didn't hire them because they were not a U.S. citizen or permanent resident, and therefore you discriminated against this person on the basis of their citizenship status. And now we're going to come in and do a full investigation, which means witness interviews, asking for your I-9s, going through the entire investigatory process. And they found, the Department of Justice found, that SpaceX discriminated against asylees and refugees in its hiring process by putting on their job ads that it could only hire U.S. citizens or permanent residents, citing erroneously to the export control regulations, international traffic in arms regulations, and the export administration regulations. And they said, hey, just because these restrict access to controlled technology, actually, asylees and refugees can have access to controlled technology, and therefore you're discriminating against them based on their citizenship status. The Department of Justice also alleges that there are other positions that don't have access to controlled technology that should have been open to more applicants than just U.S. citizens or permanent residents. SpaceX is obviously countersuing. They're saying, hey, we opened it to everyone, and we'll see how this sort of plays out through the court system. But right now, here's the potential consequences that SpaceX faces. One, back pay for asylees and refugees who were detained or denied or deterred from employment or denied employment on the basis of their citizenship status, civil penalties, which are fines, revising their employment practices, having to undertake training of the recruiting and hiring staff. They might be subject to departmental monitoring, which could go on for years. And of course, there's a beautiful press release that we now know about and we're reading about in the news. So all of these things happen from one call from an asylee who said, hey, I think I'm being discriminated against by the small immigrant and employee rights section. Here's what you need to learn or know as an employer as you're thinking about this investigation and what it means for you. Not all government contracts, not all positions subject to those export control laws restrict access to U.S. citizens and permanent residents. So if you have in your job ads U.S. citizens only or U.S. citizens or permanent residents only, make sure that your government contract actually restricts who can access that technology or who can work pursuant to that contract. The flip side of that is if you have job advertisements or you have put it out there that, hey, this job would be great for somebody on a student visa who has practical training work authorization with the hope of broadening your applicant pool, you could be found to be deterring U.S. citizens from applying for that job. More broadly, the Immigrant and Employee Rights section wants to make sure that employers are not asking their candidates for more or different documentation during the I-9 process than is required. So if you have a permanent resident who's applying and you as the employer are saying, hey, please hand me your permanent resident card, that could be a discriminatory practice under the statute. Also, just making sure that as you go through the I-9 process, you're not automatically rejecting documentation. It might be expired, but maybe that work authorization documentation has been automatically extended. So an important reminder for employers to take a step back, do a little investigating before you automatically reject documentation during the I-9 process. Speaking of I-9s, there's a lot of new things with the I-9, a new form, a new remote verification process. Christine, tell us about it.
Absolutely. So hello, everyone. My name is Christine Fabin, and I am a partner and one of the co-leads within Husch Blackwell's Business Immigration and Global Mobility team. For those of you who are familiar with Forms I-9, you will know that I could spend 5 hours easily talking you through the I-9 considerations, the processes. I have a total of 3 minutes and 27 seconds, so this is going to be a very high-level overview. However, please, please, please drop your questions, your comments in the Q&A box. I will happily respond to those once this session is done. So, as I mentioned, and as Kelly mentioned, there was and is a new I-9 being rolled out. A couple of months ago, the Department of Homeland Security notified us that they would be rolling out a new I-9 that would need to go into effect by employers on or before November 1st. So, for those of you who have not yet rolled out the new I-9, keep in mind that you have 3.5 weeks left, give or take. And the form I-9 is new and is different. We've listed out some of the changes on the slide, but I would really encourage you to go through, read the instructions, check the I-9 handbook, because it's slightly a different beast, this Form I-9. I will say that I think the thing that employers are the most excited about is the ability to remotely verify documentations with this updated form. So here's what I will tell you. If you are not an E-Verify employer, so for those of you that answered no on that questionnaire, you can tune me out for the next 2 minutes, go get yourself a cup of coffee. But for those of you who are employers, who are E-Verify employers, this is a really new, very exciting development. You will know it is a massive change from how we've done things historically in the I-9 space. Again, I will point you all back to the instructions in the handbook. There are rules around how to implement this remote verification that really need to be paid attention to and considered when rolling out, excuse me, remote verification of the documents as they pertain to the I-9. But definitely a very exciting time and very, very different than what we've seen in the past. So the last thing that I'll kind of note and discuss are the considerations outside of the new physical form and the remote verification. I will kind of focus my attention on the E-Verify state requirements because we've seen an uptick in state audits and enforcement. And just a couple of notes on that. For those of you, obviously in Missouri and Kansas, we've listed the E-Verify state requirements on the slide. But I will say, if you are an employer whether or not you use E-Verify in Missouri or Kansas and you conduct business outside of Missouri or Kansas, or you have employees outside of Missouri or Kansas, please also pay attention to the rules of that third-party state in which business is being conducted. I think in total, there are 24 to 26 states that do have E-Verify requirements that are regulated by the state itself. So if you're doing business in Tennessee or South Carolina or Florida, please make sure you're paying attention because the last thing we would want is for some sort of state E-Verify audit to come down the pipeline and to find out we're not being in compliance. So with all that said, again, please feel free to drop us a note if you have any questions about E-Verify compliance, the new I-9, remote verification. We are happy to be a resource for you all. And with that, I will hand it back over to Julianne. Thanks, Julianne.
Thank you, Christine and Kelly. And thank you for clarifying these new and very complex rules for employers to keep in mind. Our last presentation is, we're going to shoot it over to St. Louis. We have Brittany Falkowski and Scott Myers discussing issues related to having an aging workforce. Relevant to their presentation, on a scale of 1 to 5, how would you rate your organization's readiness to address the challenges posed by an aging workforce? A, or 1, not ready. B, or 2, somewhat unprepared. C, 3, neutral. D, fairly prepared. Or E, fully prepared. While you put your answers in, I will introduce Brittany and Scott. Brittany splits her practice between counseling employers and litigating in state and federal courts across the country. She is known for building long-term partnerships with her clients, fully integrating herself to better understand their business and how they operate, as well as how she can help them reach their goals. Brittany's favorite Halloween costume as a child was dressing as a ballerina, specifically for the tutu. And she does not discriminate when it comes to candy. She likes it all. Scott is a labor and employment attorney in our St. Louis office. He counsels clients on all matters of labor and employment law, from complex litigation, wage and hour compliance, and internal investigations on day-to-day human resources issues. As I mentioned, Scott has a particular focus on wage and hour issues and extensive experience defending employers against collective actions under the Fair Labor Standards Act and similar state laws. Brittany and Scott, it appears that most of the respondents are fairly prepared or fully prepared, though some feel neutral about their preparedness. So tell us, what should people be doing and thinking about?
Well, thanks so much, Julianne. We really appreciate that introduction. And as Julianne mentioned, I'm Brittany Falkowski, and this is Scott Myers. I'm a partner here in St. Louis, and although our slide here references Scott Myers as an attorney, he was recently promoted to the partnership, and that will be effective January 1. So we're all very excited for Scott. We are going to be talking today about the aging workforce and what employment law implications that may have on your workforce in particular, and how you can get ready for it. It sounds like some of you are already getting ready for making sure that you've got benefit plans in place, succession plans in place, and so on and so forth. But there might be some things that we can, tell you about today to give you some practical tips for additional ways in which to get ready for the workforce aging. So to kick it off, I think we just want to start by sort of setting the stage a little bit, panning kind of out to a 50,000 foot view or a 100,000 foot view, and giving you some statistics around the aging population. And this slide in particular is talking about the global population, not just limited to the US. And some of these, I think, are not totally surprising given what we just all generally know about people living longer these days. But when we showed some of these stats to our colleagues, they were surprised by some of these numbers. So we thought it would be worthwhile to share them with you as well. Today, retirement age and older adults outnumber children under 5, which I think is not necessarily that surprising of a statistic, but in the next 20 years, adults aged 65 and plus are going to increase by 600 million to over 1.3 billion and will comprise more than 22% of the global population. That statistic in particular was pretty surprising for us as we got ready for this presentation. And I think maybe even more surprising is that by 2040, the average age in America is going to be 38.6. A lot of you on this webinar know that the protected age group starts at age 40. So that means by age 2040, about half of Americans will be in that protected status.
Yeah, so, Brittany's talking about how individuals are living longer, and not only are they living longer, but they're working longer. Mm-hmm. And that's really the crux of what we're talking about today. Is in the past, a lot of employers kind of had a general idea when employees were going to be retiring. But that doesn't seem to be the case anymore, as the statistics have kind of shown, is that employees just frankly are working longer. And I for one, was surprised when I saw these statistics, because I think we've heard a lot about over the last couple of years what's been called the Great Resignation, about how during COVID, a lot of the older workers were deciding to, take their retirements, tap into their 401ks and go ahead and stop working. But maybe that is a little bit more anecdotal than it's actually evidence, because the statistics would show that employers are working longer than ever. Not, some of the reasons why, it's hard to say exactly, but individuals are obviously living longer. Some people don't have the savings that they may be used to in earlier generations. And the Social Security Administration gradually increasing the full retirement amount naturally is going to cause people to work longer. So again, these are just kind of some of the statistics we wanted to show you guys to maybe put in a context about why this is something that you should be thinking about now, because maybe in the past you haven't noticed an issue with older workers or any of the challenges that might come along with that, but we would expect those challenges to perhaps present themselves in the future given these demographics and how they're changing. So this is kind of the roadmap that we're going to use to take you through our presentation today. We're going to start with talking about some of the types of claims that you might see. We're going to use some real life examples, some of which you guys might be aware about. It's been situations that have made the news, and kind of how the arguments were presented in those cases, and some tips that you can take from those cases on how to avoid finding yourself in a similar situation. We're going to then transition into a little bit more practical guidance on some of the things that you guys are dealing with on a day-to-day basis. Recruiting and retaining older talent. That's something that's probably coming up more than handling complaints of age discrimination. So we're hoping that can give you some real life, advice on how to better recruit and retain older talent. And then some things that maybe you might not be as aware of, whether it's succession planning, mandatory retirement, or even when you have to go through a separation agreement with an older worker. All of these topics, we are going to try to hit on them with enough detail to make it useful, but we certainly could have done presentations on each of these topics alone. So please, please don't hesitate to ask questions or reach out afterward if you feel like you are needing more information about anything we talk about. So Brittany's going to start off by giving us some insight into the complaints that we're seeing with age discrimination and how prevalent those might be.
Yeah, so something that's probably not going to surprise anybody who's tuning into a labor and employment seminar is the first bullet point. The Age Discrimination Employment Act, the Missouri Human Rights Act, and the Kansas Age Discrimination Employment Act all prohibit discrimination on the basis of age, harassment on the basis of age, and retaliation for complaining of age discrimination. And they all prohibit that for people who are age 40 and older. Something that might surprise people who are tuning in today is that according to a recent AARP study, more than 40% of workers over 40 say that they've experienced age discrimination at work just in the last 3 years. And if I had to bet on this statistic, I would say that people who are between 40 and 50 are probably the ones who are answering no more frequently to that question than people who are 50 and above. Also interesting, nearly 40% of the same people polled cited ageism as their top concern when looking for work. And I think this one's interesting, and you and I talked about this, because we have seen so much more turnover in the last few years, and people not necessarily remaining committed to their same jobs or their same employers, but rather seeking other jobs. And so then that brings us to the last bullet, which I think in light of these other two becomes less surprising, which is that the age discrimination caseload for the EEOC is 20 to 25% of the charges that they receive. So that's a pretty big number when you consider all of the various types of discrimination and retaliation that the EEOC investigates. To me, the takeaway then is that of these people who are saying that they experience age discrimination, they're feeling very comfortable going and complaining about it, which is something that we should all be mindful of.
Yeah, so 1 in 4 or 5 cases that the EEOC is getting is for age discrimination.
Yeah, and I think that that's obviously something that's interesting in light of the fact that I don't think that the EEOC has age discrimination as one of its topics that it's interested in, pursuing every year. They post like what are going to be their main objectives, and age discrimination is not frequently at the top of that list. So we want to talk to you a little bit about some of the cases that we see and what are some of the unique characteristics or more unique characteristics of age discrimination cases. And one of the things that I think we see more often with age discrimination cases than we do with, say, sex discrimination or race discrimination is that there are allegations of age-related remarks, either as direct evidence of discrimination, which means it would be directly tied to the adverse employment action, or as pretext evidence. So stray remarks that are attributed to the decision makers that then the plaintiff alleges means that there's some discriminatory motive. So the first case is one out of the 10th Circuit, which is where Kansas sits. So we thought it would be appropriate to give it as an example. There was an employee for Frito-Lay, who's a sanitation worker, who's actually just 40 years old. And his supervisor, in the context of talking to him about his upward mobility at the company, which to date had included 4 or 5 promotions, made some comments that the employee later used as evidence of potential discriminatory age animus in a promotion case, so a failure to promote case. One of those statements was, I know historically it's known that older managers are let go, but just keep working at it, keep working hard, adding value, that sort of thing. Another comment that the decision maker was alleged to have said is, we're going through a youth movement, and so therefore we went in a different direction for the promotion. And those comments were enough for the 10th Circuit to actually overturn summary judgment, which had been granted by the district court, and find that there was an issue of fact for trial. So, sometimes I think we can think about age-related comments, and these don't seem like they necessarily were intended to be discriminatory, but obviously then they're used against the manager in a way that is not going to be great for the company. The other case that we have on this slide is Wagner versus IBM, and some of you may be familiar with this case because it was splashed across the news. It was a class action that was filed by various older people who worked for IBM and who alleged that they were systematically discriminated against and forced out of their jobs in favor of younger workers. And in this case, the allegations around age-related remarks were slightly less overt. Instead, the plaintiffs alleged that there were coded terms used within corporate planning documents, and this kind of relates to what we're going to talk about in a little bit with respect to succession planning. But those coded terms were, look, we need to correct the seniority mix. We need to continuously talent refresh. We need to shift our headcount toward early professional hires. They combined those comments with some statements that were made publicly by the CEO, including one on national television where the CEO was boasting about how many millennials that IBM had hired in the prior year. So those types of comments, and we'll talk a little bit more about this when we get to the portion about recruiting and retention. These comments may seem innocuous, but the takeaway is that they can leave you with some potential liability.
Yeah, and before I move on, that the Wagner case, Brittany, the one where the appellate court overturned that summary judgment. Appellate courts are sometimes reluctant to overturn a trial court. So the fact that they overturned it based on what can appear to be innocuous comments just shows how risky it is to make any type of statement that could indicate there's some type of opinion on age.
Right. Yep.
Okay, we've got some good news, I guess, in the case law that we can talk about, and that's this causation standard. And for age claims, it's known as a but-for causation standard. And we found a case also out of the 10th Circuit that really displayed what that means and how that come into play, Ostro v. Globecast America. But before I get into that, I just want to give a little bit more background on what causation standards are. The Title VII and the federal anti-discrimination statute, those are the race discrimination, sex discrimination, claims like that. Those are reviewed under what's like the mixed motive or motivating factor causation standard. Someone just has to show that their race or their sex was a motivating factor in an employment decision, but there could have been other lawful factors that were also motivating. Contrast that with the but-for standard. That one is higher. They have to show that but for their age, because of my age, this decision was made against me. It doesn't just have to be a motivating one. It basically has to be the reason. If I was not in this protected age group, this would not have happened to me. And so an example of how that comes into play is this Ostro case. That case, the plaintiff was a 60-year-old former in-house counsel for Globecast, the employer, and Globecast was letting go of that 60-year-old and was promoting a 37-year-old with considerable less experience in his position, but the 37-year-old made quite a bit less money. So Ostro, the plaintiff, had sued the company for age discrimination. And the company's defense was, look, we made this decision as part of a cost-cutting measure. The evidence showed the company was going through some real financial difficulties. And the fact of the matter is this younger employer happened to be compensated less. And when the court looked at this, they said, okay, even if age might have had some type of factor, it certainly wasn't the but-for causation. Here, the evidence truly does show that there were financial difficulties, and companies are allowed to take cost savings measures. And just because age may be correlated with higher compensation doesn't mean that age is the but-for reason that the plaintiff was let go. Now, that doesn't mean you can always just say, we're going to let go of someone. If we're letting go of someone older, we're doing it because they make more money. The evidence really has to show that it was a legitimate cost-saving measure. There were other people let go who were not in the protected age group, but were highly compensated. So the evidence really did show that it was truly a cost-saving measure. But that's just a case where, had that not been age, if it was viewed under a mixed motive or a motivating factor standard, it may have turned out differently. I want to talk about Me Too evidence. I just said the but-for one was a little bit of a good news. I would say this one, not so much. Some of you might be familiar with this one. It's the Cox v. Kansas City Chiefs case. It is a case that made some headlines in the state of Missouri a few years ago. And in that case, there was a plaintiff who had sued because he had lost his job as part of a restructuring and had the only evidence that this plaintiff personally had regarding his discharge was there was a comment that was made that the organization wanted to go in a more youthful direction, and the fact that the individual was 61 years old. That was really it. But the rub here is that the plaintiff had 17 other people who basically raised their hands and said, wait, I think I have experienced similar treatment. I also was mistreated because of my age, and I also maybe had heard one comment that was made. And so the court said, I don't have to just look at what happened to the plaintiff. I can look at what happened to all these other people as well, and then I can make the decision that I think that it was more likely than not that the Kansas City Chiefs were targeting these individuals because of their age. So what that's good, it wasn't a class action type claim where the IBM case, where everyone was banding together to lodge claims. This was just other people who maybe didn't have a claim against the company, but was coming forward saying, I think I have also been mistreated, not necessarily making a claim, but here's what happened to me. And that was enough for the court to find liability. So that's really just a reminder that even if you think you've done everything right with respect to one person and you think, oh, they can't never prove this case against me, be wary that there might be other individuals who feel similarly and they could come forward to help support that case. Okay, we're going to transition now and out of talking about litigation, get into some of those more practical advice. And I think recruiting and retention is probably one of the main issues that I hear about the most when it comes to managing an older workforce. So the easiest thing you can do, if you're going to do anything today after this presentation, it's to make sure that in your EEO policy, you have age listed as a protected class. It's not like that is going to be a defense to any future claim, but if you don't have it on there, it doesn't look great if you are accused of age discrimination or harassment. So just make sure age is listed in there. It probably already is, but if to the extent it isn't, go ahead and put it in there. The part that I think is really interesting is talking about job postings and job descriptions, and this language that appears age neutral, but could be potentially ageist. And there is case law that has found where it is implying that the company is targeting younger workers at the expense of older workers. So having things in a job posting like recent college graduate, high energy, fast paced, tech savvy, background in social media, that doesn't appear to have anything to do with age. You're not saying I want a younger worker, but you're using terms that seem to indicate that you might be looking for a younger job candidate. So instead of recent college graduate, even though, you know, someone can graduate college at age 50, maybe consider calling it an entry-level position. Describe the position instead of the candidate you're looking for. Those other things, high energy, fast-paced, tech savvy, those are kind of, they're just extra fluff. They don't really mean that much. You can probably remove them and it's not going to harm your recruiting or retention efforts. But I would think it's a good idea to just go through, look at your job postings, see if you have anything in there that might appear innocuous, but if you think about it, could end up making it look like you're targeting younger workers, and consider removing those.
Yeah, and so some additional things that you can do, and some of these might seem rather obvious, but I think we get enough questions about them, or we get enough, you know, inquiries about how to deal with the issues that it's worth repeating. So obviously offering training programs and promotional opportunities to all employees, not just singling out younger employees. I did have a client call not too far in the recent past with a client, a complaint from an employee who she was training somebody who had been hired to perform the exact same job as her. And her manager was lauding her for all of the ways in which she was doing such a great job, not only doing her job, but then training this person as well. Ultimately, that person gets promoted and she asks her manager, well, how come I wasn't put up for the promotion? And the manager, I think very sort of innocently says, well, look, I'm really concerned about retention and succession planning here. And I know you're planning on retiring in a couple years. And so I just really need to make sure that I retain her so that when you are gone, I have somebody who can continue to do this. I mean, that's almost direct evidence of a reason why you wouldn't promote somebody who is older, and these people were 30 years apart. So again, it was just an allegation. It was a complaint that needed to be investigated, but these things do happen. We also highly recommend training your supervisors and managers on risks associated with those comments related to age. I think, you know, you can ask somebody when they plan to retire, but you shouldn't target that question toward older people only. You also shouldn't tie age to retirement. I know we've gotten allegations in cases before where someone had alleged that, you know, people who were of equal age, actually. One said, hey, you know, we're going to be eligible for Medicare soon. Are you planning to retire? That kind of comment can be construed as age discrimination because it's tying Medicare, which is, you know, available to individuals who are 65 and older, to retirement. Same kind of concept on the next bullet point, which is jokes about age. I think people sometimes feel a little bit more comfortable talking about age in the workplace than they might about other protected characteristics, especially if you share that protected characteristic. I know when we were preparing for this presentation, you told me about a situation where a client called and said they received a complaint from an employee who was just talking with their manager about what they did over the weekend. And the manager and the employee were talking about how they were having a harder time getting down on the ground and playing with their grandkids. And ultimately the manager said, oh yeah, us dinosaurs, you know, we can't keep up with those young ones anymore. And that a complaint was generated from a comment like that. So even your older workers need to know, even your older managers need to know that they can't make those comments in the workplace. It's not all bad news. Like Scott said, there's the but-for causation standard, but there's also great ways to leverage the talent that you have from your older workers. Older workers are historically known to be more committed to their employers and want to stay and work for them. They also have a tremendous amount of, you know, knowledge to share, institutional information to pass on. And so you want to make sure that you are leveraging that appropriately. And one way you can do that is by implementing a mentorship program. Similar to some of our other advice, you don't want to limit the opportunity to participate as a mentor only. You also want to let older people be mentored if they want. But it's a great way to make sure that that knowledge is shared, which kind of brings me to the last point and is a good segue. You want to be very intentional about that knowledge shared. We have been getting a lot more questions from clients recently about how do I succession plan without stepping in a major, you know, pothole when it comes to age discrimination and getting a complaint like, you know, the ones that I was just mentioning. So one of the things you absolutely want to do is you want to identify critical positions for succession planning. Not every position needs to be succession planned. You just really need to identify what are the ones that if this person left tomorrow, we would be in a real world of hurt if we weren't able to have somebody who could step into those shoes right away. And once you identify those positions, either more broadly or just with respect to them, you ask people to complete career planning assessments. I do get the question a lot, like, can I just ask people when they plan to retire? Because I need to know so that I can plan for it. And you can ask people when they plan to retire, but it's probably not the most advisable. There are other ways you can go about getting an answer to the same question. And that's through this career planning assessment. Ask people if they plan to work for your organization in 5 years, and if not, why. Ask people if they have an interest in being promoted, if they have an interest in relocating. I mean, all these questions can be asked either in connection with your regular performance evaluation process or outside of it in response to a survey. And lastly, on this slide, with respect to the succession planning dues, do document discussions around retirement when they come up, especially if you are planning on replacing the person before they actually retire. I have gotten a lot of calls recently from clients who have had that discussion, who have gone through the replacement process, and then the person who's planning to retire comes back and says, actually, I'm not quite as financially ready for retirement as I wanted to be, and I'm going to push off my retirement date. And the question to me is, can we hold people to their retirement date? And my first question in response is always, what documentation do you have from that first conversation? A lot of times it's not much, and so then we're having to go back and make sure that we get the documentation in place, and we can absolutely do that, but it's so much better if you do it up front.
So a lot of what Brittany just said, you can think, the opposites are the don'ts, right? But there are a few things I want to highlight. It's really important to not assume employees are going to retire based on their age. We began this talk about how employees are working longer than ever. So it's extremely important to not act surprised if someone indicates that they're not planning on retiring. And that kind of goes along with some of those other bullet points, right? Don't express an opinion when someone might tell you that they're not planning to retire. When you are doing retirement planning discussions, certainly don't mention age, don't target those invitations at it. You might have a kind of like a discussion during the lunch hour at work where you invite employees to come and hear about some of the retirement benefits. Don't limit those invitations to just older workers. Don't make comments like, well, we know some of you are getting near retirement age. All of that stuff are just easily avoidable things and can ensure that you're not going to get yourself into hot water by making those comments that appear innocuous, but again, can be troublesome. I'm just going to briefly touch on mandatory retirement because I think it might be a misnomer that you can have a mandatory retirement at your place of employment. It's very rare that you're allowed to do that. You can have it for non-employees. So like an accounting firm or a law firm where there's equity partners, they're not considered employees. So you can have mandatory retirements. Whenever age is a bona fide occupational qualification. So an airline pilot, they have mandatory retirement ages. Sometimes police officers or firemen, those have mandatory retirement ages because public safety is a huge consideration there. But just saying, our job is a very complex, as a software engineer, and we think that a younger person is sharper and better at it. That's not a bona fide occupational qualification. That's never going to pass muster. And the final one, again, it's more for governmental entities, high policymakers. State of Missouri has mandatory retirement ages for its judges. That is an example of where a high policy maker, they're saying that judge has to retire by age 70. That has passed through the courts and has been approved. But outside of that, you really can't have mandatory retirement.
Perfect. So there will come a time when you will separate with an older worker. You'll separate with workers of all ages, but when you do separate with workers who are over the age of 40 and you want to offer them a severance agreement in exchange for a release of all claims, there are certain specific requirements that you must go through in order to get a valid release of those age discrimination claims. And that's because the Older Worker Benefit Protection Act, or OWBPA, amended the Age Discrimination Employment Act and added all of these requirements. So if you are just eliminating a single individual and you're asking for that release, you have to give them 21 days to consider the release agreement, and you have to give them 7 days after they sign to revoke it. Unless you're seeking that release agreement in connection with a group termination program. So what is a group termination program? Well, it can be either a voluntary program or an involuntary program. And it's basically just anytime you are offering sort of the same sort of package to 2 or more people. So if you have 2 or more people who are being let go for performance reasons, that's not a program. But if you have 2 or more people who are being let go as like a cost savings measure, or because you've determined that you don't have you have got too much headcount within a certain part of your organization and you're offering severance to 2 people and even just one of them is over 40, you have to comply with these additional information requirements. So what are they? Well, the waiver has to be knowing and voluntary. It has to be written in plain language. You increase the 21-day consideration period to 45 days. You still have to give the 7-day revocation period. You have to advise them to consult with counsel, and you have to give them something in exchange to what they're not already entitled. And obviously that just is similar to anytime you get a release, you have to give some sort of consideration or severance benefit for it. You also have to provide a notice of group termination, which gives information about the decisional unit. And I think this is probably the most challenging part of going through this process and making sure that you are appropriately giving the information needed to get that valid age waiver. So I'm going to let Scott talk about what is the decisional unit.
Yeah, so if any of you have ever gone through a group termination and you've let someone go as part of that who's over 40, you've probably seen kind of the excerpt that we have up here, a notice of group termination. They all generally look like that. And this is something that is given alongside with the severance agreement. And if you are seeking an age release, this has to be included. I'm not going to go into great detail on what has to be included on there, but basically you need to identify your decisional unit. You need to list the eligibility factors. Sometimes the selection criteria is what it's called, which are basically just the indicators that you looked at to make your decision, whether that's seniority, your performance, or skill set. Those need to be included there. You have to identify the job titles and the ages of all the eligible employees, and then those who were selected or not. So this is not just including the individuals that were actually being let go. It's also including the individuals that were selected to stay. Don't include ages. You're just doing job titles do include age. Don't include names. You're just doing job titles and ages, and then whether they were selected. So we'll end today by giving a little bit more info about decisional unit, because defining the decisional unit is kind of the linchpin to all of this. If you define it too narrowly or too broadly, you're going to find yourself into some trouble because the information is just frankly not going to be accurate for what actually happened. So when you're doing, let's say you're doing a reduction in force and you know you need to reduce headcount by 5 people, and you're going to look at both the accounting and the manufacturing departments. If you are looking at those as a whole and you can select 5 people and then maybe they're all accountants or they're all manufacturing, that's going to be one decisional unit. But if you're saying, look, I'm going to review accounting and only accounting, and how whatever decision I make on accounting has nothing to do with the decisions I make in manufacturing, those are going to be 2 different decisional units. And the individuals only get information about their respective decisional unit. So you don't want to be oversharing and you don't want to be undersharing. And that's why it's critical to make sure you are defining your decisional unit by considering how the actual process of these decisions are being made.
Yeah, and only people who are over 40 get these notices of group termination. So if everyone who's being separated is under 40, then you can wipe your hands of it and not have to go forward with the analysis. But if anybody is over 40, it is critical that you provide this information.
So that's going to wrap up our presentation today. Thank you guys for tuning in, and we will send it back to Julianne for some closing remarks.
Thank you, Brittany and Scott. That was a great presentation with both legal and practical considerations for employers dealing with older workers in the workplace and also managing risk. Well, everyone, thank you so much for joining us today. We hope the information we shared was helpful to you and to your organization. As a reminder, the program has been approved for HR and legal continuing education hours. To report your hours, please click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. As I mentioned, we do use your feedback to plan future programs that are applicable and relevant to you and your business. This concludes our program. Thank you very much for joining us.